While speaking on India's 60 Minutes verdict, the Supreme Court Commission on Food Security said that providing 35 kilos of food grain to the poor was the top court's order, not a recommendation, and the government cannot change it.
In fact, I was very disappointed that Supreme Court orders are not recommendations. This is binding in nature. It amounts to almost a law. And in 2005, they had laid down that everyone, and they had given some categories, that these are the categories: homeless people, single women, women-headed households, all those people, disabled people, must be given 35 kg of food grains. So government cannot reduce that entitlement. That's very important. And lastly, I would say that unless you broad-base the whole scheme, you cannot just cover 25% or 28% people. The legislation must provide that government would be proactive in finding out who are the people who are not getting 35 kg of food grains every month, because the record of government in fulfilling rights so far is very poor. If you look at Narega, government's own statistics shows that last year 1.10 crore, more than a crore people worked for less than 15 days in a year. But only in 43 cases unemployment allowance was given. So therefore, unless government itself is proactive, you can't expect a poor person to go to the court and claim for his right. At the same time, the law must provide for total revamping of the various programs, whether this is PDS or midday meals program or ICDS or old age pensions, plus agriculture, of course. All these programs, they must be revamped and they must be made sustainable. They must ensure good delivery.
Tuba.com